say you're sorry.
Today, I will present about the detail on legal capacity of a minor with reference. Legal capacity is the authority granted by legislation to someone who is a natural or legal being to make agreements that are enforceable and to initiate and defend lawsuits in its own name. The capacity of an individual to enter into agreements can be a natural or artificial person, although a person with a clear mind will usually possess full capacity to enter into a contract. They may argue that the arrangement is unenforceable for a variety of reasons, involving undue influence or mental impairment at the time of the agreement. Corporate entities are likewise subject to contractual capacity. Although the legal age for minors varies from nation to nation, the majority of states set the legal age at 18 years old. According to the general rule that applies to contracts entered into with children, they are not legally responsible for any contract that they enter into voluntarily or unconsciously. Based on Kaufman and McDonald, 2007, page 476. However, this does not absolve the other party from fulfilling their end of the bargain. If they break the agreement, they must pay a small compensation. However, if the minor decides to authorize the agreement when they reach the age of majority, they are bound by it as of the date of ratification. As the minor reaches adulthood and decides to dissolve the agreement, he gets released from further obligations. On the other hand, certain contracts that a minor enters into bound him to their terms. This includes agreements for the supply of necessities, contracts for employment or other benefits, and agreement for similar supplies. Another class of contracts are voidable at the minor's discretion, but they become binding on him once he reaches majority and does not withdraw from them within a reasonable period time frame subsequently. Based on Kaufman and McDonald, 2007. Next, I will pass to next presenter, FATHIAH.
Thank you, MASHITAH. So now, I will continue the presentation about the legal capacity in scholarship, insurance, and necessity. Firstly, what is scholarship? The contract for scholarship is another exception under the minor contract. The regulation governing scholarship agreements has been set out in the Contracts Amendment Act of 1976, Section 4A, which states that no scholarship agreement should be void because the party entering the contract is a minor. Based on the Government of Malaysia v. Gucharan Singh and Ors in 1971 states that the issue in this case was whether a scholarship for a student who was a minor and was undergoing practical training overseas amounted to a contract for necessity. The agreement between the government and the minor was declared by the High Court to be invalid and unenforceable. The Contract Amendment Act of 1976, Section 4, was passed as a result of the above cases and states that no scholarship arrangement shall be voidable on the grounds that the individual making the agreement is not of the age of maturity. To conclude, if a minor accepts an offer to further his studies, his agreement to acquire a scholarship is valid and unenforceable. While a minor violates the contract, he is liable and may be sued under the terms of the agreement. Next, I will go to another section, which is insurance. Insurance is also an exception to a minor contract. According to Section 153 of the Insurance Act 1963, revised in 1972, a minor over the age of 10 may engage in an insurance contract. If she or he is under the age of 16, the written consent of the parent or guardians is required for the contract to be valid. The Insurance Act allows a minor to enter into a legitimate agreement for an insurance contract. This exception is based on the minor's best interest to protect himself or his property from contingencies. Then, the last one, necessities. Contracts relating to provision of requirements are one of the agreements which make up the majority of the exceptions to the general rule that minors lack legal capacity. According to the law Nashvi Amendment in 1908, the other party to the contract must demonstrate that their agreement with the minor was made out of a necessity. Services and products are both considered necessities. In the case of Chappell v. Cooper in 1844, it was decided that a minor's agreement to dispose of his parental figure was a necessary contract. Depending on the circumstances of the case, including the minor's age and social standing, it will be determined if the contract is precisely necessary. The circumstances that are considered necessary are typically those that a person is unable to survive beyond.
Thank you to Fathiah. Now we move to question B. The issue of this situation, whether there is an offer in the NURLIYANA case. An offer is a promise to do something or refrain from doing something in exchange for another conditional action, commitment, or forbearance. It acts as a signal that one or both parties are prepared to engage in a contract, as well as an invitation to the other party to ratify the agreement by providing their permission. When accepting the offer made by the offeror, an offeree converts into the acceptor pursuant to Section 2C of the Contract Act of 1950 CA 1950. Other than that, invitation to trade ITT is a prior communication that takes place during talks that might result in an offer between the parties. ITT is only an invitation to inspire offers and not a formal request for an offer from one party to another. Therefore,
The decision to accept or reject a customer's offer is up to the person making the ITT. In addition, there are 4 examples of ITT which are advertisement, display of goods, auction sale, quotation, and tender. Advertisement is a corporation advertising in a newspaper or on its website that it has a limited amount of a specific product available at a given price. This advertisement is classified as an invitation to trade, since it urges potential clients to make a purchase offer. Next, the display of goods is when items are presented at a store or exhibition. It is commonly regarded as an invitation to trade. Customers are encouraged to make offers to purchase the display goods by signaling their intent to purchase, such as picking up an item and taking it to the checkout counter. A call from the tender is usually an invitation to trade, and the submit tender is the offer. If the investor states that they will accept the best tender, they must do so, and a contract will arise with the best tender. Now I will pass it to the next presenter, which is SAADAH.
Thank you, Farah. As we observe in the specific case of Rihanna, we can argue that since there is not an offer in this situation, there might not yet be a contract between the seller and the buyer. The only thing that occurs is the invitation to trade done by the seller. In this case, we are able to apply the court's ruling in the Pharmaceutical Society of Great Britain versus Boots Cash Chemist Ltd in 1953 case, which determined that the display of products is simply an invitation to trade and not an offer. Only once the buyer picks up the items, bring them to the counter and pays, make the deal valid. The court upheld the idea that the exhibition of flick knife in glass windows is merely invitation to trade, while it rendered the same judgment in the second case, namely Fisher versus Bell. Next, we go to application of law. In the Section 2 of CA 1950 applies in Rihanna's situation, as she has not made a legally binding contract with the seller regarding the vest purchase. The fact that Rihanna brought the vest to the counter to pay does not imply that she is making an offer or entering into a contract. As the seller has not yet accepted Rihanna's offer, which implies the seller has not received Rihanna's payment, the offer she made to buy the vest is not yet complete. To conclude, it is important to note that legal outcomes can vary depending on jurisdiction and specific circumstances. It may be beneficial for Rihanna to consult with a legal professional to understand her rights and obligations in this situation based on the applicable laws in her jurisdiction. The offer is not valid and the contract is not legally binding in this case. Therefore, Rihanna is not liable to pay for the vest. That's all from Group 6. Thank you.